Hello, everyone, and welcome to today's webinar. My name is Connor Spencer, and today we're going to be discussing Don't Sign That Contract Yet, essential reviews every business must do before signing. The title should really be For the Love of God, Don't Sign That Contract Yet. And hopefully by the end of this webinar, because we're going to harp on it quite a lot, you'll agree that it's both strategically important for your business, but also just plain common sense to check through a number of things with your document and finalize it by getting it reviewed before signing. For any of you who are subscribers on our essentials or on a legal advice plan, I'd strongly recommend now to get into the habit and muscle memory of having your docs reviewed moving forward. As obviously you already have that ability to book in a next working day consultation as you need it. And we know that actually contract reviews is one of our leading areas of topics consultations are booked under for, and by far one of the most utilized services as a whole. And what that gets you obviously is the unlimited on-call contract reviews, and that's both for your internal and external documents. And obviously, no employee is the same, no client you bring to the business is the same, or potential partner or investor. So you don't want to really be using the same carbon copy document every single time. You want to make it the right fit for you. Overall, I'm yet to hear a single downside to having a document reviewed. About 99% of people do not have a formal legal background, and so they are using the advice to either understand what a specific clause means or asking what should I actually be including and adding to this existing document to tailor it to my business. And importantly as well, how can the language be written in so it's clear or as clear as possible and not open to interpretation. And the latter certainly helps protect businesses and gets you ahead of your competition. So I think for a moment if it's a client or a supplier you're engaging with, whether your arrangement where you have potentially thousands of dollars on the line, are you going to chance it or should you begin that contract reviewed? Obviously, if you have an employee or contractor or distributor agreement, you might need to include some firm terms around non-solicitation or non-compete, or potentially something around like an NDA if you're about to approach someone and share confidential information. Having a bespoke NDA is crucial. Having any bespoke version of a contract is crucial, just so that you're prepared for any eventuality and you can enforce your terms. So it really pays for itself to have a contract reviewed before anyone puts pen to paper. You won't find a single highly successful business that does not have a lawyer reviewing their fine print. And it's best business practice to get expert advice to ensure your contracts and agreements are tailored to your needs and bespoke as possible. So we'll go in a bit more detail shortly about LawPath and how we directly assist. I'll introduce Damon, who will be discussing today's topics. Damon will be covering legal requirements for a contract, just ensuring they're valid and enforceable, types of contracts, such as employment contracts, lease agreements, and service contracts. He'll discuss negotiating contract terms and clauses. That's really key, and common issues that may arise in the contract signing process. Finally, we'll conclude with a Q&A session where you'll be able to submit your questions in the Q&A chat box. It is a separate button from the general chat. You'll see we have two there. So please, if you have any questions specific to the topic, add them in there and we can address them at the end. So as per usual, today's webinar will be joined by Damon Murdoch. He is LawPath's principal lawyer. He has been practicing for decades and has extensive experience within this field, as well as other legal areas in business and commercial lawyer. If anyone wants to actually view our Meet the Lawyers page on our website, you can see our lawyers who deal with our legal advice plan clients. You'll see, for example, Damon has a 5 out of 5 star rating out of over 300 reviews. And if you're coming to us for the first time, if you're new to LawPath, we are an Australian-based online legal platform. We've been operating for a good part of 10 years now, and we've helped over 500,000 small to medium businesses in different capacities within that time frame. So we are essentially tailor-made for startups who need the service to fill in their gaps in legal knowledge, but you also need it to do in such a way that obviously saves them money with their startup costs. So while we have lawyers and accountants actually of no affiliation using our platform, and in fact, about 8,000 of the of 12,000 registered accountants in Australia actually use LawPath. The bulk of our clients do not have that formal legal and accounting background, and they need to know what they don't know so they can have a bit of peace of mind and not worry about any potential or accounting issue popping up. You'll see we possess a 500 legal document library. These are all up to date with Australian legislation, which has been drafted by lawyers. And as I mentioned, and particular to this topic, you get unlimited on-call contract reviews of our lawyers on the platform. And by doing so, we've essentially saved the individual business owners thousands of dollars in legal and accounting fees. But across that last decade, across Australia, we've saved small businesses over $100 million. So for anyone who'd be interested in hearing that from first-hand experience, you can visit our website, read our reviews, read our video testimonials on our YouTube page, and I'll include that in the general chat if anyone wants to hear what clients using the platform are actually saying about us. But that's enough from me. We'll jump straight in. I'll hand things over to Damien.
Great, thank you very much. Thanks, Connor. Hello, everybody. Welcome to today's presentation. So today we're going to primarily talk about contracts. We're going to start at the very fundamental side of what is a contract, what's a deed, whether you can have it electronically signed, and then we'll get into a little bit more detail, a little bit more complexities. And we always find the most valuable aspect of this is your Q&A. So if you have any questions, pop them in the Q&A. And even if you don't have questions, it's worthwhile hearing others because they're probably similar issues to what you might have. All right, so let's start off with the very foundation when we look at a contract. So a contract needs to have an offer and an acceptance. So what is an offer and acceptance? We get into a lot of different areas of law on each one of these elements, but the main thing to look at is for a contract, you need an offer, an acceptance, a meeting of the minds, so you understand what you're actually agreeing to, and consideration, an exchange of a detriment for a benefit. So an offer, someone might verbally offer to sell you their car, and then you verbally accept it. That's a contract. Even though it is not in writing, it's still a contract. And a lot of people say, oh, well, verbal agreement isn't worth the money, or verbal agreement isn't worth anything. That's incorrect. Most of our cases are actually in court about verbal representations, verbal contracts, and breaches of those contracts. The problem with a verbal agreement is you actually have to prove it. So if you had a written contract where someone signs off on a contract, then you've overcome the biggest barrier, which is proving that there was an agreement. But if you don't, then it's going to come up to your representations, your conversations, your text messages, your emails, and a verbal conversation costs a lot more money to enforce than a written one because you have to prove that that was what was actually agreed. So you normally want to have a written contract, but just because you don't have a written contract doesn't mean you don't have a contract. So the offer, promise not to do something, promise to supply goods, promise to supply services in exchange for a price. That's the offer. The acceptance is someone writing, I accept. Now, it's not uncommon that acceptance can be in various different forms. So there can be a written acceptance, there can be an implied acceptance. So if you've ever had a recruiter, for instance, and you maybe had an ad up on Seek, and a recruiter sends you an email saying, here's my business terms and conditions, and we have some candidates. Do you want some candidates? You say, sure. You accept those candidates, you interview them, and then you hire them. The recruiter will then come back to you and say, you now owe us our fees. And you say, well, I didn't sign anything. And it doesn't matter because in their business terms that they sent to you, it says by receiving a candidate and by interviewing that candidate and by hiring that candidate, you implicitly accept our terms and conditions. So you can still have acceptance by implication. Another example might be someone sends an employment contract, the other person doesn't sign the employment contract, but doesn't object to it, and then gets the salary that they were promised, gets the position title that they were told, does the job responsibilities that they said they would, all specified in the employment contract, then there's a pretty good indication that that person has accepted the terms of the contract by implication. Now, if someone makes an offer and someone else comes back and puts track changes in the document and sends it back, that's actually a rejection of the original offer. And by sending a document back with track changes, that's a new offer. So it's a counter offer. So again, when we're trying to settle cases in court, I might make an offer, pay 100,000. Someone else writes back, say, well, 90. Um, they've rejected that $100,000 offer. The minute they reject it, it's off the table. So if you are negotiating, just know that the minute you reject it or counter offer it, it's rejecting their offer, and their offer is automatically withdrawn. Now, the next one is consideration. Now, this is an important aspect of all contracts because consideration is something that people don't necessarily always cover in their contract. And by not covering it, it can result in the contract not being legally binding. And from legalese terminology, it's called want of consideration, which basically means that the contract's failed because there's no consideration. Um, an example might be where someone's lent you $10,000 and then they say, well, look, I've already lent you that money, but can we record that into a document and turn it into a proper loan agreement and add 10% interest on it? And you say, yeah, okay. So you go and sign the contract. Well, that contract's probably not legally enforceable because the consideration, the actual payment of the 10,000 already happened. So and we have a maxim in law that's called past consideration is not good consideration. So if someone's already lent you money in the past and then you formalize it in the future, there's no benefit to you signing off on a contract when you've already got the money. So you're not receiving anything because you've already received it. And so in these kind of circumstances, we do what's called a deed instead. So a loan deed instead of a loan agreement, because the difference between a deed and an agreement is that a deed doesn't have a requirement for consideration. So if you're ever going to go about and get an agreement signed off after the fact, that after you paid money or after you received a service, just remember it should be a deed, not an agreement. And then the last one is an intention to create a legal relationship. And most of the time in court, where a contract fails, including a verbal agreement, it's because that element can't be proven. So it's the intention to create a legal relationship, but also it's what's called a meeting of the minds. It's the parties understand what they're agreeing to. And to understand what you're agreeing to, the contract can't be vague, ambiguous, or uncertain. And that's where a verbal agreement will not be legally binding because it can be vague, ambiguous, or uncertain. You might not have the essential elements of what you need for a contract because it's simply not clear enough. So, for instance, you might say, I'll buy your land and pay 100 grand for your land, and I'll settle that in 2 months. Well, you know, is that clear enough? We have the Conveyancing Act, and there's certain elements that need to be met in the Conveyancing Act. You normally, if you've ever bought a piece of land, you'll see that there's a contract that's 30 pages, and that spells out what happens if someone defaults, what happens if they don't sell, delay, settlement dates, payments, strata fees, council rates, adjustments that need to happen for electricity, water, things like that. So there's a lot of things that if it's ambiguous and uncertain, then the court can't be forced to try to interfere with your transaction and impose certain things that just didn't exist in the contract. So that's normally why a verbal agreement might fail, because you don't have enough detail in that offer and acceptance and the actual terms of the contract to make it a crystal clear contract that the courts can actually enforce. Also, an agreement to agree is not legally enforceable because there can't be an intention to create a legal relationship where you don't know what it actually is. So if you have an agreement that says, I'll pay you $50,000 for your software, and we'll enter into a software agreement or software development agreement in the next couple of weeks. Well, you don't know what they're going to build, what the functionality is, what the specifications are, when the delivery dates are. You don't know anything. And so an agreement to agree to a future agreement is not legally enforceable. Now, you can say that, we will use reasonable endeavors to enter into an agreement in the next 30 days in good faith, and negotiate in good faith and cooperate with one another to reach an agreement. That might be a little bit more binding, but it's not the actual terms of the agreement that's binding. It's the duty of good faith and the duty of cooperation, which is the binding element of that agreement. So it's not the actual forcing you to enter into a contract, it's forcing you to use reasonable endeavors, cooperate, to act in good faith, to reach an agreement. And again, there's no obligation for you to actually enter into that contract if you don't agree in good faith that the terms are fair. So those are a couple things to consider when you're looking at whether a contract's going to be legally binding. Now, I mentioned that there's deeds, and a deed is essentially the same thing as an agreement, but it doesn't include the consideration. So when we say past consideration is not good consideration, that doesn't apply for a deed, but a deed has a different execution block. There's a different way of signing it. And that's where it needs to be signed, sealed, and delivered. And what that means is that it has to be signed and exchanged. So unlike a contract, you can have implied consent. With a deed, you can't. So it has to be signed. It has to be sealed, which means that if it's an individual, it has to be witnessed. And if it's a company, it has to be signed properly by the directors of the company. So if you have a sole director, secretary, one person, if you have two directors, both directors. So it has to be properly sealed or signed by the company and delivered. It has to actually be exchanged. Now, there's different laws in terms of signing contracts and signing deeds. So signing contracts, we have the Telecommunications Act in most states that allows that anything that says you can sign a contract or sign a document in writing means you can sign a contract in writing. However, a deed isn't the same. When COVID came in, they temporarily changed the law to allow deeds to be executed virtually by way of an audio video link where the witnesses is also in that Zoom, for instance. But certain states have implemented permanently and certain states have not. So there are some states that still need a virtual witness. There's some states that remove the witness requirement. There's some states that don't allow electronic signatures and still require wet ink. And so every state's slightly different. And then there's also another area of law which is called implied terms. So for instance, you might have a contract and you say, I'm going to sell my goods or sell my services. And then you have a general disclaimer, limited liability, indemnity clause, and it says, this is a final sale and you have no recourse to a refund. You don't get your money back under any circumstances. Well, that's against Australian consumer law, and you can't contract it out of Australian consumer law. So that means that your limited liability clauses are not legally enforceable and will just simply be struck out completely by the court, because the Australian consumer law says that any clause that purports to exclude certain statutory rights that a consumer has is not legally enforceable. So when you're selling goods, for instance, they have to be merchantable quality. They should be new unless you specify it's used. It has to fit the description. So if you don't disclose with a proper description on your website what it actually is, then there's an implied guarantee on that. There's a implied guarantee that the goods are going to pass title, so the ownership's going to transfer across. In terms of services, it's going to be delivered within a reasonable period of time with due care and skill, fit for purpose. So whatever was represented that that service is going to deliver, it's going to have to deliver that. And so you can't contract out of these. So whenever you have a limited liability clause, and it's worthwhile for you to look at your services agreement and see if you do have one of these, if it says that we are not liable to you for anything, then it's probably not legally binding. So as lawyers, we normally say we exclude our liability to the maximum extent permitted by law, but nothing in this limited liability clause excludes any guarantees within the Australian consumer law. However, if the Australian consumer law does apply and it's a sale of a good, then the total liability of us is for the resupply of that good. or a refund and nothing more. And if it's a supply of service, it's a resupply of the service or a refund and nothing more. And so that's preventing you from having what's called consequential loss and damages, or exemplary damages or aggravated damages. These are all circumstances that might arise where there's a breach of contract. An example is there was a case a long time ago where someone was they ran a sawmill. They had a big shaft that they needed to get fixed. And so they sent it off to a company to get rectified. They said, if we don't get this fixed and returned to us within X amount of days, then we're going to suffer a significant amount of loss. Can you guarantee that you're going to fix this and get it back to us? And they said, yes, we can. And then when they didn't, they got sued for consequential loss, which was all the lost revenue that was derived by or that should have been derived by the sawmill because of the failure of them being able to actually deliver on time. And so you can be liable for consequential loss. So when someone says, can you sell me this good and have it delivered in the next 7 days? And you say yes, and then you don't, and they suffer loss and damage as a result of you not delivering on your promise, then you could be liable for an open-ended amount of consequential losses. So that's why an exclusion clause is important, and that's why you normally exclude consequential loss, exemplary damages, aggravated damages, loss of reputation, damage to goodwill, things like that. So those are a couple things to think about, because these implied terms and implied law automatically is in your contract, even though you don't mention it. Now, just looking at some different contracts that are more industry specific. So when you're looking at an employment contract, I have a bunch of clients that say, well, we have a lot of casuals, but we don't give them an employment contract. They're casual, they're under the modern award, so that covers everything. It does, but there's different things that you probably still want in a casual agreement, like what are their roles and responsibilities? What are they just going to get paid the modern award? Are they going to get paid greater than that? But you also want a clause that says that they're going to comply with your policies and procedures. So when it comes to occupational health and safety, when it comes to taking leave, when it comes to not showing up for a shift. And so that's why a casual should still have an employment contract that binds them to being bound by your policies and procedures. And then you also have, when you look at full-time, part-time contracts, you want to be setting out, and the most important aspect is the termination clauses. So you want to be setting out possibly a non-solicitation clause, which says that they're not going to solicit away your clients, they're not going to solicit away your customers, they're not going to solicit away your suppliers, possibly a restraint of trade clause that says they're not going to start a competitive business. Depending on their seniority, people say, oh, restraint of trade clause isn't legally enforceable. That's not true. They're regularly enforced every day in the Supreme Court. It's just a question of whether it is legally binding, having consideration to have the breadth, how wide it is, how long it is, what's the geographical location of it, whether it's against public policy, things like that. But focusing on termination. So if you are hiring someone that needs a driver's license, you want to have the right to be able to automatically terminate if they lose their license. If they're a lawyer and they lose their license as a lawyer, you want to be able to terminate because they can't fulfill the duties anymore because they don't have their licenses and so on. So same thing applies with forklift driving, things like that. You want to look at absenteeism. So if they don't attend for 2 to 3 days, you want to have a termination clause that you can terminate them immediately if they don't appear and don't tell you why they haven't shown up. You want to look at whether you have a probation period, and if you do, what the notice period is. We have a lot of times where a client will just insert into their employment contracts, either party gives 4 weeks notice of termination. That's great because the employer will give you, or the employee will give you 4 weeks notice of their termination before they leave somewhere else. But it's not so good that if you've hired someone for 4 weeks and you realize they're not very good, and now you're stuck with a contractual obligation to give them 4 weeks notice, even though they're not any good. So have a look at the notice period. Make sure you have a clause that they're bound by the policies and procedures. And talking about policies and procedures, if you are a subscriber to LawPath, you want to look at the employee handbook. The employee handbook has about 16 or 20 different policies: occupational health and safety, sexual harassment, annual leave policy, work from home policy, things like that. So have a look at those as well. So when you look at an employment contract, again, a lot of times people will put bonuses or commission into the employment contract and the commission structure. We always recommend against this because an employment contract is fixed. Once you give that to someone, someone accepts it. You can't just unilaterally change the contract. So you can't just go and change the commission structure or change the bonus plan, especially if it's going to adversely affect them, being the employee. So you normally say you're entitled to participate into our commission plan or our bonus scheme, which is a separate document. And that's it. And then in the separate document, because it's a policy and procedure of the company, it can be amended from time to time by way of reasonable notice, and as long as it's fair and reasonable, but you can amend it. Whereas the employment contract, you can't change. It's locked in. Another thing is we normally say, if you have a work from home policy, you don't say in your employment contract, you have to work in the office 2 days a week and work from home 3 days a week. Instead, you say you have to work from the office 5 days a week, but you can participate in our work from home policy from time to time. And then at the time of employment, you can say, well, our current work from home policy is you can work 3 days a week from home. But if you don't have it in the policy and have it in the employment contract, you're never going to be able to bring them back 5 days a week ever, even if they're employed for 20 years. So those are a couple things to consider about an employment contract being fixed, your policies being agile, and you want to put anything that's going to amend or fluctuate to be put into a policy, not into the actual contract itself. Looking at leases, so a lot of people are signing leases. There's a difference between a lease and a license. We really found that out during COVID. So if you're in a co-working space, you don't have a lease, you have a license to use that space. And with a license, it's just a contractual right, whereas a lease, it runs with the actual land itself. So if you have a lease for more than 3 years, you can register that in most states against the property, so that if your landlord goes to sell the property, then the incoming owner has to make good that lease. They can't just simply kick you out because it flows with the actual land. But when you're also looking at leases, if you're ever taking over a lease, you got to be very, very careful, because when you take over a lease, you're taking over the exact same obligations of the past tenant. So what that means is that if you take over a lease and the tenant hasn't paid their rent or hasn't paid the outgoings, then the minute you take over the new lease, you're now liable for that. Or another thing is, if you take over a lease, it might be that the previous tenant has done a fit out. So they've changed it up and put in partition walls, put in a kitchen, whatever it is. You now have an obligation, because you've taken over a lease, to make good at the end, put it all back how it was when the previous tenant got it. And you might not even know what that looks like, and find out it's going to be $20,000 to what's called make good back to the original position. So taking over a lease can be a little bit dangerous. You got to do some due diligence. Also, when you have a lease, you want to look at what the special conditions are. A lot of times, if they use a real estate institute standard form contract, that's normally good. It's a standard form, and then they'll put special conditions at the back. Those are the most important aspects of that lease to look at. And if you're given a lease agreement that doesn't have a logo from the Real Estate Institute on the front page, then it's probably really important that you read it from start to finish, because it's the lawyer that's prepared this contract, and it's probably very favorable for the landlord, possibly more favorable than what a standard form contract would be. So you want to look at whether you're responsible for maintaining the air conditioner, whether you're responsible for making good, whether what you have to do, whether what happens if there's a fire, what happens if someone's injured. Are you responsible for all the outgoings? Are you responsible for the land tax? So you got to really be really careful about signing a lease. I highly recommend you get advice on that. especially if it's not a standard form contract, has special conditions, or it's a contract that has a logo from a lawyer on the front page, for instance, because it means that they've customized a specific clause or a specific agreement, specifically going to be much more favorable to the landlord. When you look at service agreements, most of the disputes are not because of um, someone provided poor service or someone provided goods that are defective. It's normally a miscommunication. That's what most disputes are about, is people not having that meeting of the minds, people not actually knowing exactly what they're going to get and what they're not going to get. You see a lot of times with SaaS products, like software as a service, it will say, this is what's included, this is what's not included. But if you upgrade to the silver package, this is what's included, but this is not included. And if you upgrade to the gold package, this is what you get. And the reason why they've done that is to specifically say what you do get and what you don't get, because it's the exclusions that are sometimes the most important aspect of a contract. You see this all the time in accounting, where someone will hire an accountant to do the company tax returns, and then when it comes tax time, they haven't filed the BAS, or they haven't done the tax returns for the holding company, or they haven't done the tax for the individuals, and they say, "Well, I thought you were just going to do it for all," and the accountant says, "Well, no, our contract says we're only doing it for your trading company," and that's just poor communication from the accountant. They should have said, we are only doing it for your trading company, and there's an extra fee for individual tax returns and for a holding company and for anything else. And that's where it becomes important that if there's an assumption that things are going to be included, you want to explicitly exclude it so there's no dispute later. Another example is website design, for instance. If you, it doesn't normally include unlimited changes, right? So you want to be specific. This includes preparing a design concept, you reviewing it, making one change to it, us then developing it, us making 3 changes to that, and so on. You want to be specific in what you're actually doing. Other things with the services agreement, if you have an employee, all the intellectual property that's created by the employee while they're employed doing their duties is owned by the company. If you hire a contractor to do services for you, it's automatically owned by the contractor. The intellectual property does not go to you. It's just licensed to you at best. So if you have a services agreement, you really need to have an intellectual property clause that says that anything that a contractor does for you is owned by your business. And you want to, again, have a non-solicitation clause, limited liability, termination provisions, what kind of warranties you have, pricing, payment, scope of services, exclusions. These are all really important elements to have in the contract to prevent a dispute. Because if it's not clear, then you could end up not getting paid. They could be negligent in their services because you guys didn't know what they were supposed to deliver for you, things like that. Now, when we look at negotiating contracts, as lawyers, we look at the best alternative situation and the worst alternative situation. And we might say, okay, well, if it's a really big contract, we'll say, okay, there's 10 things that we really want in this contract. But there's 5 things that we really do care about. But what we'll do is we'll take those 10 things, we'll request changes to those 10 things, and the other side will have the 10 things. And you'll concede on, you'll say to them, okay, well, we'll give you that if you give us this. And we'll give you that if you give us this. And by the end, you get your 5 and they get their 5. And it's a good negotiation, which both people are going to be happy with. But if you don't go in knowing what you want and what you're willing to budge on and what you're not willing to budge on, you end up sometimes accepting a contract that's totally unfair, and you're just doing it because you're desperate. So that's where you come into a bargaining position scenario. And so you really need to know before you go in, what's the price you're willing to charge? What's the best case scenario of what your hourly rate's going to be? What are you willing to accept? But knowing that if you don't get this, you'll walk away. So a couple things to look at for that. Most contracts nowadays should be mutual. So mutual termination clauses, mutual breach clauses, mutual indemnity clauses, mutual limited liability clauses. So if you're reading a contract and it says in favor of one person but not the other, that should trigger something. This is probably not a fair contract. So look at the termination contracts. If they can't terminate, or if you can't terminate, but they can in certain situations, it's probably unfair. And under the unfair contract terms under the Australian consumer law, if your business is a consumer, then there's situations where you will be able to possibly say that certain clauses are unlawful. But the only way to find a contract unlawful is to take it to court. So it's not uncommon. We have someone saying, this is not fair. We delivered the service. They haven't paid us. And we say, well, yes, from my opinion, they're in breach of the contract. But unfortunately, just because they're in blatant breach of the contract, you can't actually do anything until you get a judgment from a court. We can threaten it. We can tell them that we're going to go after them for that plus interest plus legal costs. But until a judge actually signs off it and stamps it and says, yes, that was a breach of contract, there's nothing you can do. Now, when it's a blatant breach, lawyers normally get involved and can say, we're going to go for indemnity costs, or we're going to go for summary judgment because this is so obvious that it shouldn't even be able to be defended. But just note that just because you have a contract, just because there's a breach, doesn't mean a lawyer can resolve it overnight, and it might be you have to actually go to court. And if there's an unjust contract term in your contract or in their contract, it might appear as an unjust contract, but it's not unjust until a judge decides that. Now, the Australian Competition and Consumer Commission, the ACCC, are currently prosecuting a lot of larger companies for automatic renewal clauses and for fixed term contracts that has a penalty if you want to go out or get out of the contract. So if you have a subscription where someone pays a 1-year subscription and they're locked into that and they're paying monthly and they decide to terminate after 3 months, and you say, okay, that's fine, you can terminate, but you have to pay us out the entire 1 year. That could be seen as a penalty clause, and it could be unenforceable. Now, the way to get around that is that if it's a genuine pre-estimate of your loss. So take LawPath, for instance. LawPath based its business based on the number of subscribers it has. The more subscribers it has, the more it pays in advertising costs, the more salespeople it hires. Its business is fundamentally based on subscription. So it needs to have what's called contract certainty to know what their annualized recurring revenue is going to be for it to make decisions moving forward to hire more people, make certain decisions, borrow money, things like that. So although you might have a locked-in 12-month contract, in certain circumstances, that's going to be legally binding because they have to have contract certainty, and the courts understand that. So if you do have that, then you normally draft a clause that makes it very clear. We need to have contract certainty. We're going to be hiring more staff because of this. We're going to do this and that. So it has to be a tailored contract with tailored clauses if you're going to lock someone in for an extended period of time. And if you have an automatic renewal, then you're probably going to be wanting to give them notice that it's going to renew, or at least bold it and make sure they're aware that that clause exists. Now, if you're looking at a contract generally, you want to be starting to put into your calendar different due dates. What are the obligations? When do they need to be done? What are the payments? So on. And if they have obligations to you, you want to not miss those dates. So make sure you have a calendar entry, you're booking it all in. So again, just talking about construction contracts, for instance, if you're building a home, you want to know the dates that they're supposed to be progressing, the dates that everything's supposed to be done, so that if they don't, you're on the ball, you know what to do, you know to jump to the contract, look at the obligation, tell the builder that they haven't complied, and so on. And the same for any kind of contract. You want to try to prepare a timeline, because most contracts are over budget, over time, and you need to stay on top of all that. And the only way to stay on top of that is to have contract obligations with specific due dates and put them in your calendar and follow them up. So another thing is, if you look at entering into business with an international company, you could have a contract with a company in New York, for instance, and you could say, okay, I'm going to provide these services to you. You provide the services, you issue the invoice, and they don't pay. And you say, okay, great. My contract says Australian law applies. And so I can now take them to court in Australia. And you can take them to court in Australia. You can get a judgment against them here, but they don't have any assets here. They're not based here. The courts can't do anything against that company. And so now you've got to go to New York and probably start the case all over again and run a brand new case in New York under Australian law, which doesn't really make sense because a New York lawyer won't really know Australian law and it becomes super complicated. So we have something called the New York Convention, which is the New York Convention for the Enforcement and Recognition of Arbitral Awards. It's done by the United Nations, and there's 151 countries around the world that have signed it. And basically that says anyone to a commercial agreement, they can mutually agree what law applies and where the dispute will be resolved. So you could now have a contract with a New York company and you can say, well, Australian law will apply. And if there's a dispute, it will be resolved by way of arbitration, not by court, by arbitration, which is slightly different in Australia. And then if they don't pay their invoice, you take them to arbitration, you get an arbitration award here, and now you can take this decision to 151 countries around the world and enforce it against the assets of your customer in all those countries. And all those countries have a law that has to recognize the arbitration award. So now you just go to New York and say, hey, I have a decision, please stamp it. And now it's as good as a New York judgment. So if you are doing international law or international business, have a look at the New York Convention, Wikipedia, whatever, get an understanding of how it works. You can look at UNCITRAL, which is or you can look up New York Convention and you look at modern clauses or standard clauses. You also have the Australian Commercial Arbitration Center, I think, that has a standard form contract for that as well. So that's just one point to know about. And that's about it in terms of this slide. Again, we're nearing the end, so if you have any questions, pop them into the Q&A, and I'll be passing it over to Connor in a minute. We've already talked about your negotiations, but it's amazing if you watch like Pawn Stars, where you see someone walk in and they're going to sell a guitar, and they say, "Okay, I will not take anything less than $800." And they're like, "Oh, it's actually probably only worth 200. Do you have any? You know, I'm not going to pay 800. What's your best deal?" And they'll say, "Okay, well, 600." And they say, "Oh, okay, well, I'll offer you two." And then they accept two. When you do negotiations as a lawyer, we never bet against ourselves. We never bet against ourselves. And that basically means I make an offer of $800. The other side says, no, we're not going to counter it. That's it. You just keep going. You do not reduce the offer that you made. You need to get them to reject your offer and make a counter offer before you make another. Otherwise, what happens is you just go down, 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 and you end up going where they're going. So you want to, if you make an offer, you need to get a counter offer. And if someone says, "Oh, I'm not, I don't accept that, make a better offer," just say, "I'm not going to bet against myself. You make a counter offer, I'll come back." So that's just one point about negotiations. And as I suggested, you want to get your best case scenario, your worst case scenario. You want to meet somewhere in the middle to get an outcome. The main thing that we have in terms of issues when we're actually enforcing contract disputes is, one, the contract wasn't properly signed, it wasn't implicitly accepted, or the parties aren't actually right. So if you are going to sign up to a contract and you just put, LawPath, well, LawPath isn't a company. It's LawPath Operations Pty Ltd. So if you just have LawPath, well, who are you enforcing it against? LawPath, the holding company, LawPath, the operation company, LawPath Legal, the law firm. So you need to make sure you put the actual Pty Ltd company into the contract. And another thing we see all the time is people put the director's name. Well, the director's name is not providing the services. It's the name of the company, the ACN of that company to make it legally enforceable. And then also getting it signed. A lot of people go through the whole process of negotiating a contract, then they never sign it. It's just crazy for me when you try to enforce something. It's like, why would you negotiate this and not actually sign it? So if you do sign it, make sure you get the other side to send you back the signed version. Make sure you have a copy, you save it somewhere, especially if you do it in DocuSign. I'm dealing with one right now, and my client can't find the contract. It says, I'm sure it was signed at one point, but I can't find it. We have a convertible note deed where my client sent a convertible note. The other side sent a text message saying, yeah, this is all good. And now the other side's claiming it was a loan. And I said, well, where's the signed deed? Well, we don't have it. Well, a deed needs to be signed. So we have an issue. Even though there's possibly an implied consent, it's a deed. And to enforce a deed, you got to get it signed. So make sure you get it signed, make sure the parties are correct. I have another one right now where the client was told to go do some services, and then he's issued invoice and he found out the company actually doesn't exist. It was deregistered. And so now who do you go against? You have to go against the person that made representations for them, and you sue them for misleading, deceptive conduct, which again is a lot harder than just simply doing a breach of contract. So those are a couple things. These are the formalities of signing. If it's one director signs. If there's two directors sign. If you have two directors, secretary, you can have one director, one secretary. If it's sole trader has to sign. And electronic signatures, they're great. You have a record of them signing. You have the IP address, the MAC address. You have the digital audit at the back. You have it safely, securely stored. I always recommend going e-signature. It's nice, quick, efficient, and you normally have that record. So I'll pass it back off to Connor, and then I'll be back for Q&A. So if you have any questions, drop them in the Q&A. As I mentioned, that's normally the most valuable. Also, we have a YouTube channel where we do a bunch of videos, bunch of webinars. So if you ever have any questions about shareholders agreements, term sheets, capital raising, corporate structuring, trusts, we have videos and all of that. So jump onto our YouTube channel as well and like it. And I'll pass it back to Connor.
Thanks, Damon. Yep, as you said, we'll cover the Q&A questions shortly. So if you do have any questions fresh on your mind, please pop them in the Q&A chat bot now. We'll just go for a quick overview of how LawPath can help, just a bit more specific to the topic. Obviously, if you have any existing contracts, it can be policy documents, employment contracts, or maybe more company-related documents or your service agreements, or even if you're planning to create new or updated ones for review, I'd recommend checking out our legal advice plan. So a lot of your documents or existing documents may already be out of date or are potentially about to be out of date when changes in law around employment get made around this time of year. And what we do is we supply your business with over 500 legal documentation. These are all up to date. They're all drafted by our commercial lawyers, and they're actually already 99% complete and ready to go. You just need to add in all of your relevant information to specific clauses, or you can actually customize and add in your own clauses that way. If anyone would actually like a demo of the platform, even if you're already on our essentials and have someone show you in real time how to complete these documents, please just let me know by typing yes in the chat, or send me an email to request that, and we can organize that time for that. What else do you get? You get unlimited edits of these templates, and most importantly, unlimited on-call contract reviews. So look, these documents can be drafted by yourself in 5 to 15 minutes, but if you are then still unsure about specific pages or existing clauses in the contract, or you have questions about what should I be including, don't wing it. You can use the legal advice plan to speak to our legal team and get that peace of mind. And I'm sure as a business owner, all of you will be no doubt trying to save every dollar you have. So it's good to know like the market price for an hour's consultation of a senior lawyer for even general advice is around $600 per hour. Because it's end of financial year, we're actually providing you with unlimited consults for the year for just $1,100. Plus, these subscriptions are 100% tax deductible. They're classed as digital business expense, so you can speak to your accountant or use our accountant to get this written off for this business tax return. We often hear a complaint from people who then join our platform that previous lawyers they had like delays when speaking to them. With LawPath, you actually are connected to our legal team with a live chat, but then you also have same day or next working day consultation. So again, if you're using the platform and you run into a specific clause in the document, you're not sure what it means, You can either stick it in the live chat to get a quick answer, or book in a time to go through a bit more the nuances of that specific clause. I've actually included in the chat where you can actually read the hot topics we discuss outside of just contract reviews. These are not all the topics for which we discuss with business owners, but they are definitely the most popular. And these stem from business structuring advice, business purchase and sale, employment and HR advice, huge one. Intellectual property and trademarking is a huge one. Debt recovery and commercial property law. And if you also want to have your lawyer and accountant on the same page with one another and to keep your legal and accounting under one roof, you may want to actually look at our most comprehensive package. You can also get unlimited consultations with our award-winning chartered accountants on the legal and accounting advice plan. And fundamentally, you can see it again in the link, but what everyone wants to know is understanding specific types of tax. So that's your GST, your PAYG, crypto tax, interestingly, is included now, capital gains tax. But the real pull with that advice package is getting advice around tax minimization strategies. So that can be your tax concessions, knowing what you're eligible for, and what you can also claim as tax deductibles. And the advice all about that is just allowing you to make smarter financial choices. It's a real, I know this is a real kick in the teeth when you realize after the fact what you could have had deducted from your business's tax return, as it's money you could have funneled back into your business and less that you have to send over to the ATO. The accountants also offer some business structuring advice or restructuring, and this stems from general advice to situationally specific structuring advice, which they bill at a projection rate. You may be considering switching from a sole trader to a company, or looking at a potential now trust structure, or incorporating a new entity, and you'll want to know the tax benefits of each of those. So please speak to us for that information. And of course, if you haven't got it sorted and need someone to do your tax, you can add in our tax compliance plan. Again, I'll encourage you all to visit our testimonials page and listen to our clients using us for their accounting and tax compliance. I've gone and added the link to our testimonials in the chat box, so please check that out. And it's exactly as it says on the tin. It includes your BAS lodgements, tax lodgements, and financial statements. And you do get a special fiscal year consultation to do a deeper dive and analysis of your business spending and revenue. So we'll go to the Q&A, but for all of our attendees, we have 30% off on our legal advice plan. This also includes our virtual office. So for any of you who are still using your home address as your business address, you may want to take up our virtual office end of financial year offer to increase your privacy and security by obviously not advertising where you live. But there's also a place to receive important mail, and it looks more professional to have a formal commercial address listed. The 30% off for life goes to everything from our essentials to our legal and accounting package. You have immediate access to our templates, and you'll be able to book a discovery call with one of our lawyers and accountants for tomorrow. And this is basically just an opportunity to outline your business with any short and long-term goals, discuss any pressing legal issues you're faced with, and explore any legal gaps in your business that you are not aware of, preparing yourself for the end of this financial year and prepping for the next, and where relevant, actually getting an edge over your competitors. So if that's of any interest to anyone here, please reply yes in the chat. Someone can reach out to you to discuss further. And as I mentioned before, even run a demo of the platform so you can actually see it from a subscriber's perspective. But I'll hand things over to Damien, and we'll just go through the Q&A.